In today's tip of the week, I'm going to give you a quick summary on 5 of the most frequent cases we help our clients, and the ones that we usually get more questions and comments on our videos. We are going to briefly talk about Vawa, the U visa, cancellation removal, asylum, and parole in place. The information I'll show you is just a quick summary, but I have created complete videos and playlists for each and every one of these on our YouTube channel. Please check them out if you want to know the whole process, requirements, and costs for each one. I'm immigration attorney and an immigrant, Andres Mejer. Join me. First, let's talk about Vawa. We've covered this topic in several videos, giving you updates on the changes to the law and guiding you to the process of applying for your green card through a Vawa process. Like I mentioned before, we have special YouTube playlists talking about all of these just below. So Vawa is the Violence Against Women's Act, and under it, there are immigration benefits to eligible spouses, parents, and children who have been victims of abusive U.S. citizens or lawful permanent residents. It's important to mention that Vawa applies equally to both male and female petitioners. The basic requirements to qualify for Vawa are the following. You are being abused or were abused by a U.S. citizen or lawful permanent resident. You are or were the lawful permanent resident or the parent of an abused child by a U.S. citizen, spouse, or parent. You've been battered or have been the subject of extreme cruelty by the LPR or by the lawful permanent resident or U.S. citizen family member. For spouses, you also have to show that you entered the marriage in good faith. So let's take a step back. Basically, what we're talking about is you have to be in it, and that relationship has to be one that immigration approves of or qualifies for this benefit, like a parent, a spouse, or a child. So we've had cases where children, U.S. citizens, usually have a mental disease or problem, schizophrenic, sometimes autistic, sometimes bipolar, sometimes it's due to drug or alcohol abuse. And due to that disease, they can become violent and either physically, emotionally, or both. So you're in an abusive relationship with somebody who is a U.S. citizen or lawful permanent resident. That individual is a relationship to you that immigration recognizes. You have to show that you lived with them in the U.S. when the petition was filed, or you had lived with them in the U.S. when the petition was filed. You must have lived with the abuser at some point, and you still have to show that you're a person of good moral character, meaning that you actually deserve to get this benefit. These are the basic requirements you need to apply for Vawa. If you think you're eligible and want to talk about your options, please reach out to us. We'll be happy to guide you. Let's move on with another of our main applications we do for our clients, which is the U visa. U visa is used for victims of criminal activity who have suffered mental and physical abuse. It is designed for 2 reasons. 1, to protect victims of crimes who are not U.S. citizens, and 2, to gather information regarding crimes to help law enforcement. The U visa protects you, the victim, by giving you legal status in the U.S. and allows U.S. law enforcement to stand with you against the crimes committed by criminals. As a condition, you will give valuable information to law enforcement regarding the crime. This information can then be used to track the criminal and make a conviction. It's important to mention that to qualify for the U visa, the crime had to have occurred within a U.S. territory, or basically a state, or with someone like Puerto Rico or the U.S. Virgin Islands or Guam or Hawaii. Well, Hawaii's a state, but you get what I mean. Along with that, these are the requirements that you need. You have to be a victim of one of 23 qualifying crimes. The most common ones are abusive sexual contact or sex assault or sexual exploitation, domestic violence, what federal law calls a felonious assault, meaning it has to be a sufficiently serious assault, and stalking. Now, stalking and assault and sex abuse are often also domestic violence, but not every state has a crime for domestic violence. Take New Jersey, for example. There's a statute that defines what domestic violence would be, but domestic violence in and of itself is not the crime. Assault would be the crime. Stalking would be the crime. Harassment would be the crime. Terroristic threats would be the crime. None of, by the way, it doesn't actually have to be terrorism the way we think about it, like, Islamic Jihad and things like that, or 9/11. Terroristic threats can be simply, I will kill you. Well, that could cause you terror, and it is a threat. So you have to be a victim of one of 23 qualifying crimes. You have to have suffered physical or emotional abuse. You must have information regarding the crime which you share with law enforcement. You must be willing to cooperate with the US government, with pretty much with law enforcement. That could be testifying in court. So having information might mean reporting it to the police. Cooperating might be when the police reaches out to you to get more information. Maybe they ask you to write a statement. Maybe they ask you to identify a witness. Maybe they ask you to testify in court. Any one of those would be cooperating. Victim of a qualifying crime. You have to have suffered physical or mental abuse about the crime. You need to have information about the crime. You need to be willing to cooperate with law enforcement regarding the crime. And 5, you're going to need a law enforcement certification from the police, prosecutor, the court, or other agency that has investigatory authority. Could be Division of Civil Rights, could be the EEOC, it could be Division of Child Services. It has to be an agency that has authority to investigate. It's often the police or the prosecutor, but it doesn't always have to be. Sometimes you need to be creative. And lastly, you have to be a good moral person. What that means is, if you just came out of jail for having killed someone and serving 20 years, the fact that someone punched you may not result in a U visa, given the bad that you've been convicted of. So in the totality, maybe you don't deserve this. Those are the 6 basic requirements for applying for a U visa. Once again, you can check the rest of the content we have created to get more information on each of those elements and how you might be able to qualify. Now let's talk about cancellation of removal. Cancellation of removal is an immigration benefit in which an individual like you can apply in front of an immigration judge to adjust your status from deportable to someone who's lawfully admitted for a green card. It is a defense to removal, which means you have to first be in removal proceedings in order to qualify. Now, there are different requirements that you have to meet for this, and it will depend on whether you are a green card holder or a non-green card holder. For a lawful permanent resident, meaning someone already filed for you and you received your green card, and now you're in removal proceedings. Here's what you need to show. You have to have been a lawful permanent resident for at least 5 years. You have to have continuously resided in the United States for 7 years. Means I have a client that parent filed for them. They were living outside the United States. They entered the United States from day one as a green card holder. They've been here 5 years, but not 7 years. That individual does not qualify for lawful permanent resident cancellation removal. You must have continuously resided in the US for 7 years, but you have to have your green card for at least 5. 3, you can't have been convicted of an aggravated felony that would automatically disqualify you. 4, you can't have filed for this or something similar in the past. And 5, you have to deserve to win your case. This is the good moral clause. Yes, you may qualify for good moral for cancellation removal, but if you've done some really bad stuff, for example, you have 10 DUIs. All right, not a single one of those DUIs individually would disqualify you, but because of the number you've had, you don't deserve this. If you're not a green card holder and you're in removal and you want to file for non-permanent resident cancellation removal, here are your requirements. First, you have to have been physically present in the United States for 10 years. Second, you have to have been a good moral person during that 10-year period. And third, you can't have been convicted of a disqualifying crime. And lastly, and this is the hard one for most people, you need to show that your removal from the United States would result in exceptional and extremely unusual hardship to your U.S. citizen or lawful permanent resident spouse, parent, or child under 21. So you have to have a qualifying relative. They have to have certain legal status, and they have to show hardship which meets the level of exceptional and extremely unusual. By its nature, it's exceptional, meaning every separation is going to cause harm to your relative. That's a given. Why is this separation above the norm such that you would be allowed to stay in the United States? For examples, you can take a look at our video where we go to this in detail. Let's move on to asylum. This legal status is granted when you receive protection from the United States government because you cannot safely return to your home country. As you may be very aware, every year people come to the United States seeking protection because they have suffered persecution or fear they will suffer persecution back in their country because of race, religion, nationality, political opinion, or particular social group. There's been a lot of litigation about what is particular social group or whether it's whether that one of those 5 reasons is a contributing factor to the persecution. Again, for more detail, take a look at our videos and our playlist. But first, you're gonna need to apply for asylum, and you need to be in the United States to do that. If you arrive to the United States with a valid visa or way to enter the country, you can enter the United States and then submit your asylum application within a year of when your permitted stay expires. Most of the time, it has to be within that 1 year. If you're eligible for asylum, you may be permitted to remain in the United States. To file for asylum, you're gonna have to file Form I-589, and again, you're gonna need to file timely. Applying for asylum can be complicated, so if you're thinking of going this path, I would strongly recommend you review the rest of the content I've created on the subject. If it can give you the information that you're going to need, but you're still gonna have questions and doubts. And when you do so, I encourage you to give us a call and we'll see how we can best help you. And to close this video, I want to talk about parole in place. Parole in place was established during the Obama administration, and the main goal is to allow parents, children, or spouses of military personnel or veterans to obtain lawful immigration status. A parole in place itself does not lead to an immigration status or other benefit. But after receiving parole in place, you will be eligible for a work permit, you will get protection from deportation, you will have legal entry to the United States, and it gives you a way to then file for legal permanent resident, meaning it will lead you a way to file for your green card because it's going to give you legal entry and your relative can then file for you. So to obtain parole in place, you're going to need to be the spouse, parent, or child of an active member of the U.S. Armed Forces, a member of the Reserve or National Guard, or a military veteran. If deceased, he or she must not have been dishonorably discharged. To get your green card with parole in place, you can't just jump right into it. You're going to need to, because if you do, your application is going to be rejected. So first, you have to, you must take care of the issue of your illegal entry to the U.S. or your illegal status in the U.S. And to do that, you need to request parole in place. And in order to get that approved, you're going to need to prepare and submit the required documents to USCIS, which you can find in a complete video I did on this topic. Then after you submit the application, that's for parole in place, get it approved, you can then file for a family-based application to get a video. And you guessed it, we have videos, a lot of videos on family-based applications. So parole in place gets you legal entry, it gets you work authorization, it gets you protection from deportation. With that, your relative who's in the military can then file for your green card. And that brings us to the end of this video. Again, this is just a quick summary of 5 of the most common types of cases we get and the questions that we have on a regular basis based on your comments. If you want more information on these or on other different ways to get your legal status, please check our playlists. We have several of them divided by the types of applications, and I'm sure you'll find the answers to most of your questions. But like I always mention, every case is different, and we'll have different circumstances to consider. So if you want to talk about your situation and the best path for you, please reach out to us. Remember, if we can't help you, we won't take your money. Until next time, stay healthy and be well.